Table of contents. 1. We'll learn different sources of laws, statute law versus common law. Number 2. When someone breaches the contract, there are 3 equitable remedies and 1 common law remedy. Number 3. We'll identify and differentiate between public law and private law. Number 4. We'll explain the history of real property law. Number 5. We'll talk about the trial process in BC. 6. If we win the lawsuit, but the judgment debtor said that he has no money to pay us, what are the 4 different ways to enforce the judgment? Number 7. We'll talk about limitation to commence the legal action. Number 1. Sources of laws. Our sources of law came from England. Canada was colonized by England, so England introduced its legal system to Canada. Today in BC, Canada, our sources of law are statute law and common law. And statute law is the law created by the government, while common law is the law created by the courts. And there's another way to call common law, case law. While statute law is code-based, common law is case-based. Common law is based on the previous court cases, while statute law has the spelled out written rules. Here I would like to give you a code-based law, such as Real Estate Services Act. It has Part 1, Part 2, Part 3, Division 1, 2, 3, 4. Under Part 2, Licensing, Division 1, License Requirements. The Act stipulates that to be a real estate licensee, you must be minimum of 19 years old, of good reputation, etc. And so this law is a statute law, which is code-based. Here come more statute law examples. First one, Federal's Competition Act that encourages fair competition, discourages monopoly. Real Estate Services Act regulate the resident licenses, rental licenses, and strata licenses if they are providing real estate services. And Mortgage Brokers Act regulate the mortgage brokers. If you are arranging, representing mortgage products, during mortgage transactions, administration, then you supposedly need to have a mortgage broker license. And Occupier Liability Act. If you are defined as an occupier, such as persons who are in possession of the property, then you need to ensure the third party's safety when they are using or when they are approaching your property. Just need to ensure that they are safe. And so if you see any question that asks you which of the following are statute laws, then how we can tell is we look at one word, and that word is Act. Competition Act, Real Estate Services Act, Mortgage Brokers Act, Occupier Liability Act. So long as you see the word Act. For your exam purposes, this one must be statute law. And the purpose to create the statute law is to change, to modify, to override common law. And the purpose to create the common law is to solve common people's common issue. Statute law is the law created by the government. In Canada, government has 3 levels: federal level, provincial level, and the local level. While the common law is created by the courts. And common law has 3 characteristics. Number 1, it uses the hierarchy of the courts. Some courts are higher level, some courts are lower level. And number 2, it uses the doctrine of stare decisis. And number 3, common law is rigid. And when statute law conflicts with the common law, statute law will prevail. For now, let's address the statute law, the 3 levels of the government. federal, provincial, and local. The lawmaking body for the federal government is Senate or House of Parliament, and the lawmaking body for the provincial government is Judicature. The Judicature in BC is Victoria in Vancouver Island, and local government, the lawmaking body is the Municipal Council. And an example of a law created by the federal government is the Federal Competition Act. Examples of the laws created by the provincial are Real Estate Services Acts or Mortgage Brokers Acts. And the law created by the local government has a generic term called bylaws. And there's like subdivision bylaw, zoning bylaw, or density bylaw, etc. And the laws created by the government is called statute law based on your textbook. The government has the power to make legislation. Legislation means statute law, and federal government has exclusive power to pass
banking, bankruptcy, currency, postal services, marriage, divorce, criminal matters, patents, copyrights, national defense, height and structure of building or object underneath airpath, shipping, fisheries, and harbor.
Federal government is in charge of the airport, and for buildings or objects such as trees that are underneath the federal air pass, those are going to be regulated by the federal government. If your building is underneath the air pass, your building's height will be restricted. Shipping, fishery, and harbor are related to ocean, and those three are also under the control of the federal government.
Provincial government is responsible for property and civil rights, municipal institutions, the administration of justice within the province, education, and matters of a purely local or private nature.
Local government's power is derived from the provincial government. Provincial government designates its power to the local government. Now that the local government has the power, now it can create bylaws to govern streets, traffic, and local buildings. The federal and provincial government's power come from Constitution. And then provincial government then designate its power to local governments to let local government to be able to create certain bylaws. And the laws created by federal, provincial, or local governments are known in your textbook as statute law. Which of the following powers have been assigned to the provincial governments and which have been assigned to the federal government? Now take a moment and write down your answer. Practice question number 2.
Court cases form the main part of the common law system. Another important part of our law is legislation. Which of the following could be called legislation?
We choose number 3, Strata Property Act. Legislation means statute law, and when you see the word act, it's the statute law. Let's move on to common law. Common law is the law created by the courts, and the court uses the hierarchy of the courts. Let's talk about hierarchy. Our BC civil court system is comprised of 4 different courts: Small Claims Court, BC Supreme Court, BC Court of Appeal, and Supreme Court of Canada. Small Claims Court is the lowest trial court in BC. Trial means that's where the case starts. The trial court is where all the facts of a case are heard, and a judge will make the final decision. It can compensate the case winner maximum $35,000 or less. In BC, there are several small claim registries, and where you can file your small claim depends on the territorial limitation. The claim must be filed in small claims registry nearest to where the defendant resides or where the claim arose. And defendant may mean the troublemaker. That's the person that the allegations are against. I will give you an illustration of the territorial limitation. Now, on the screen, I'm showing you the map of the court registry. Now, again, this is for demonstration purposes only. The locations of the registry are subject to change. And from this map, you can tell that some cities don't have the court registry. And supposedly, let's say today I drive my car and someone hits me. They hit me in the city of Burnaby. Now, where can I file my small claims? Be aware that in Burnaby, assuming it has no registry, then where can I file? If the accident happened in Burnaby and is nearest to Vancouver registry, then I can file my claim in the Vancouver registry. If the troublemaker, the defendant, resides in the city of Richmond, and assuming there's a registry nearest to Richmond, then we can also file the claim in the Richmond registry. So that's the territorial limitation. It depends on where the claim arose or where the defendant resides. BC Supreme Court is the highest trial and appellate court from small claims. If I lost the case at small claims court, I'm not satisfied with the decision, and I wish a higher level court judge can reverse the judgment, then I can appeal to a higher level court, which is the BC Supreme Court. That's what appeal means. So to have a higher level court judge reverse the judgment. And that BC Supreme Court can hear any dollar amount and no territorial limitation. If I lost at the BC Supreme Court, I can appeal to BC Court of Appeal. It's the highest appellate court in BC. It's not a trial court. When it's not a trial, then the judge will only look at legal issues, will look at did the lower level court judge apply the law incorrectly, and no evidence will be reheard again. 3 or 5 judges hear the appeal from BC Supreme Court. Do you know why it's 3 or 5 instead of 2 or 4? That's because we want to break even. A majority of the judges decide the matter. The more judges there are, the more complicated the case are. If I lost again, I can appeal to Supreme Court of Canada, which is the highest appellate court in Canada. It deals with legal issues only. No evidence is reheard, and it has the power to decide not to hear your case, because you only deal with a significant case, a case that will affect, let's say, nationwide, or that will affect the community, or that's significant enough. And 3, 5, 7, or 9 judges hear the appeal. Majority of the judges decides the matter. And how this relate to common law is, if this case is small, then it will be trifling. The power will be very small. But if this is a case announced by the Supreme Court of Canada, then it'll be very powerful. It'll be very binding. Remember that common law are the law created by the courts. So these courts create cases, and these cases form the basis of the common law. In the recent years, Civil Resolution Tribunal Acts created the Civil Resolution Tribunal, known as CRT. CRT is a newly created online tribunal. Tribunal is a semi-quasi-adjudicator. It does not have the strict rules as a formal court. The purpose to create a tribunal is to hopefully resolve people's issues in a less formal way, faster and with less legal fees. The CRT commenced its operation in year 2016. For small claims, it can compensate up to $5,000. If you lost your small case, you can appeal to Small Claims Court. For strata disputes, there's no monetary limitation, and if you lost the case, you can appeal to BC Supreme Court. Let's do practice question 3. To file a claim in Small Claims Court, the plaintiff may originate the action in the jurisdiction where... Now take a moment, think about the answer. And when you are ready, we'll reveal the answer. Answer 3. Either the defendant resides or the cause of action arose. It has nothing to do with where the plaintiff resides. In practice question number 4. Which of the following are false? We choose 4. Option A, B, C, D are false. As for A, BC Supreme Court has no monetary limitation. As for B, an appeal from Small Claim Court can be made to BC Supreme Court. As for C, the Supreme Court of Canada can decide not to accept certain cases such as small case. And D can be heard by 3 or 5 judges instead of 7 or 9 judges. Let's continue to talk about common law's second and third characteristics.